Hello everyone, welcome to Search and Seizure in Canadian Education. This is going to be presented by Shannon, Meghan, Courtney, and Lewis. So before we get into the background of ethical search and seizure, we just want to clarify some definitions so we're all on the same page about what we're talking about. So search is any state activity that interferes with a reasonable expectation of privacy, which is determined through the totality of the circumstances test, which we'll be talking about later. This can include tangible or intangible things such as spoken or written words, electronic data, or even in some cases it can be scents or smells. An example of this is airport screening, where officers screen personal items and carry-ons, and if they see anything suspicious, the officers can conduct a manual search of the item or bag in question. This is justified by the need to ensure public safety, and the search is conducted by following pre-established procedures. Seizure is the taking of a thing from a person by a public authority like government or police without the person's consent. This can include a physical item like your phone or a bag, or even information like a password. A taking by a public authority does not need to be directly from the person whose rights are being affected. So an example of this would be a medical professional taking a blood sample for some sort of medical reason and then handing that sample over to the police without the patient's consent. This is considered a seizure. Of course, within an educational context, the process of search and seizure must be balanced with students' rights to privacy. There are three main types of searches that we'll be talking about today. So that's dragnets, strip searches, and informal searches. The policing definition of a dragnet involves defining an area, so like a city block or a building, or a category, so a certain group of people within an area, and conducting a brief investigation of each person within. So an example of this would be airport security checking all passenger bags after receiving a security threat. Obviously, dragnets raise concerns about privacy and fairness because the nature of the search assumes everyone to be guilty until proven innocent, rather than targeting an individual suspected of wrongdoing. Within a school context, this would be something like checking all students' backpacks for contraband, or searching lockers under the suspicion that someone might have brought a weapon into the school. A strip search is a thorough and invasive search where a person is required to remove some or all of their clothing to search for hidden contraband. This is a very intrusive type of search in which psychological harm can be done to the person being searched. In Quebec, the school board relies on the following guidelines for conducting a strip search. A screen is to be used, clothing is searched, not the individual. The search is conducted under the supervision of two persons, preferably with a staff member of the same sex as the student, and no contact is made with the student whatsoever. Unless there is imminent danger, it is not deemed appropriate for school personnel to strip search young offenders. Informal searches include searching laptops, computers, or backpacks. Schools can have electronic device policies that result in confiscation, but the device cannot be searched without reasonable suspicion. There's also locker searches when the school provides students with lockers and has control and access to the lockers. A student's expectation of privacy in regard to the locker is at the lower end of the scale. Students have the right to know about the limits the school is placing on their reasonable expectations of privacy in regard to lockers. And as stated by McKay and others, the simple course of action for schools is to dispel any notion of privacy by notifying students that their locker is in fact school property and may be subject to search at any time.
So to continue on, we're going to look at 4 legal principles in regards to search and seizure. We will look at the Canadian Charter of Rights and Freedoms, the development of the Youth Criminal Justice Act, the Teacher Code of Professional Conduct, as well as the Teaching Quality Standard. So the Canadian Charter of Rights and Freedoms, both Section 8 and 24(2), have relevance to search and seizure, where Section 8 states that students have the right to be secure against unreasonable search or seizure, and that mere suspicion does not give teachers the right to search the students. There needs to be grounds to their search. Section 24(2) implies that a court concludes that evidence was obtained in a manner that infringed or denied any rights or freedoms guaranteed by this charter. The evidence shall be excluded if it is established that, having regard to all circumstances, the admission of it in the proceedings would be the administration of justice to distribute.
So we've mentioned the reasonable expectation of privacy, but what exactly does that mean, and how is it determined in relation to the charter? So reasonable expectation of privacy is the belief that a person's belongings or personal space should not be searched or accessed without consent. This generally has to be agreed upon within society. So you have a high level of reasonable expectation in your home in regard to your body or your cell phone. You have a moderate level in regard to school lockers, and you have no expectation if you just happen to forget your backpack in a public space. Everyone has access to it, so there's no reasonable expectation of privacy. The totality of circumstances test is used to determine the existence and extent of an individual's reasonable expectation of privacy. If there is not a reasonable expectation, then the protections offered by Section 8 of the Charter are not engaged. If a reasonable expectation is determined, then Section 8 of the Charter is engaged. And this is determined by the following. An examination of the subject matter of the search. So what was searched? Was it a backpack, a phone, a locker? A determination as to whether the claimant had a direct interest in the subject matter, or does the individual own or control what was being searched? An inquiry into whether the claimant had a subjective expectation of privacy in the subject matter. So did the person believe they had privacy? And lastly, an assessment as to whether the subjective expectation of privacy was objectively reasonable, or would everyone or majority of society agree that this expectation was reasonable?
So now looking into the development of the Youth Criminal Justice Act, it starts with the Canadian Juvenile Delinquents Act, which ran from 1908 to 1984. This introduced the offense of delinquency, which included criminal and non-criminal behavior. Their goal was to reform youth by placing those considered to be delinquents into custody for indeterminate periods. What came about was to help the critical issue of holding children accountable to their actions while focusing on how best to treat the child so that they could become productive members of society. Following that act, the Young Offenders Act came about in 1984 and ran until 2003. They emphasized the need to protect the public and hold youth responsible. They increased the age of criminal responsibility to 12, which before was 7. They tried to find the middle ground between paternalistic approach based on rehabilitation and treatment, as well as a punitive approach based on the harshness of the adult criminal system. So then after that started the Youth Criminal Justice Act, which started in 2003 and continues to run now. So that promotes the proportionate and meaningful responses to youth offending. It recognizes that timely and informal criminal justice responses are often sufficient to address criminal offenses. It continues to build off the strengths and the weaknesses of the Young Offenders Act and includes a differentiation between violent and nonviolent offenses and a reduction in the use of incarceration for young offenders before and after trial. It also establishes a new approach to sentencing and encourages a range of responses to nonviolent youth offenses known as extrajudicial measures. So Section 124B informs youth about their rights. So no oral or written statement can be made by a young person who is less than 18 years old to a peace officer or any other person in a position of authority on the arrest or detention of the young person, or in circumstances where the peace officer or that person of authority has reasonable grounds for believing that the young person has committed an offense, is admissible against the young person unless the person to whom the statement was made has, before the statement was made, clearly explained to the young person in a language appropriate to their age and understanding. In Section 146(2)(c), it describes the consultation of adults before making a statement. So the young person has reasonable opportunity to consult and counsel with a parent, or in the absence of a parent, an adult relative, or in the absence of that, an appropriate adult chosen by the young person, as long as the person is not co-accused or under investigation in respect of the same offense.
When understanding the background a bit more, it's best to understand how the professional code of conduct and the teaching quality standards can be linked back to it. Why you, as a future educator, need to be wary and always vigilant of these, but mainly which sections are relevant for teachers and teacher leaders to keep in mind when performing search and seizures on students. Section 1B is good to keep in mind. In relation to students, the teacher or teacher leader is required to demonstrate a welcoming, caring, and safe learning environment. Teachers must provide a caring and respectful environment to ensure students don't feel threatened, which should be used against them when performing search and seizure protocol. Finding a balance of care and authority to maintain a reasonable, safe environment for students. Section 1C, the teacher or the teacher leader shall teach or lead in a manner that does not intentionally contravene applicable legislation and policies of Alberta education. The Code of Professional Conduct demonstrates and affirms the importance of maintaining standards within the school environment, but also instruct the significance of caring for students' well-being. This understanding becomes a very much so a balancing act. Legitimate care for students while exerting discipline/authority on the basis of suspicious behavior that a student may do while in school grounds. Moving on to Section 2, it's another relevant part due to it primarily focusing on interaction between parents and teachers, where it is our responsibility to inform students' parents with discretion if we believe it would not lead to any harm on the child within the school. This could be informing them about anything illegal they might partake in, or any dangers that they could have in their belongings resulting in some form of school punishment. Shifting over to the teaching quality standards, the main TQS to pull from is TQS1 and TQS6. TQS1 speaks on about the standards of care and fostering effective relationships as a teacher's ability in acting consistently with fairness, respect, and integrity towards the student, very much in line with the code of conduct expectations of care towards the student's well-being, and E, collaborating with community services in this case within the parameters of search and seizure, which are law enforcements. TQS 6 primarily focuses on teachers' expectation of adhering to the law and policy frameworks while operating within the school, such as A, maintaining an awareness of and responding in accordance with requirements authorized under the School Act and other relevant legislation. B, engaging in practices consistent with policies and procedures established by the school authority. And C, recognizing the professional practice of teachers is bound by standards of conduct expected of a caring, knowledgeable, reasonable adult entrusted with the custody, care of education for students. These three sections dictate a teacher's role as an authority and abiding by the parameters that the government has put into place within the school. These all inform the type of actions we must have as future educators in dealing possible issues with students.
We will now go over a case on the subject of search and seizure in an educational context. For our presentation, we've chosen to cover the R versus MR case from 1998. But before we discuss this specific case, here is the legal precedent set on search and seizure within a general context. In 1984, the Supreme Court of Canada had a hearing for the Hunter versus Southam case. Southam is a Canadian newspaper incorporation. Prior to the trial, investigators were searching documents in the Southam offices. The incorporation then sued after declaring that this was an unlawful search. During the hearing of this case, Justice Dixon set out 4 principles governing search and seizure. These principles are the following. 1, the establishment of Section 8 of the Charter was created to make a right of privacy. 2, the establishment that searches without a warrant are prima facie unreasonable. This means that first impression or the presumption against the validity of the search, that the searcher must rebut. Thirdly, a general constitutionality of searches must be considered. One must not simply look at the rationality of the search, but also the reasonable or unreasonable impact on the person being searched. And lastly, there must be a balance between crime control and protection of privacy rights. This balance only happens when credibility-based probability replaces suspicion. Those principles for search and seizure were established for a general context. Years later, they were tested in an educational context during the M versus MR case in 1998. To explain this case, we have prepared a short skit that we will be playing for you now.
Welcome to Canadian News, where we break down the new and up-and-coming events here in Canada. We are here to inform you on what's happening 24/7. Check it out.
Today, November 26, 1998, thank you for tuning in to this evening news report. We begin the news from the Supreme Court of Canada. They have made a decision on an appeal for a case that was initially brought to court this past June. It started when the vice principal of Nova Scotia Junior High School searched two students after being informed that these students had drugs on them.
So the student, whose real name is protected for privacy reasons as per section 110, subsection 1 of the Youth Criminal Justice Act, sued the Nova Scotian School Board for this unlawful search. In court, the student argued that section 8 of their charter rights, which dictates that everyone has the right to be secure against unreasonable search or seizure, was violated by their vice principal. The initial trial judge deemed this search to be a violation of charter rights. Thus, the Nova Scotia Court of Appeal brought this case to the Supreme Court of Canada, which leads us to today's ruling. Here to speak with a judge from the SCC is Courtney.
Hello, thank you for joining me today, Judge. Can you please explain to me what the Supreme Court has declared in regards to this case?
So the SCC dismisses the appeal for this case. Although there's already legal precedents set out for search and seizures in a general context, we established that within an educational setting, it is a little bit different. For example, search and seizures in a school setting don't require a warrant.
Why is a warrant not essential?
It's because school authorities, so teachers, teacher leaders, people as such, they're acting as agents of the state in those roles. However, school authorities don't have the authority to do search and seizures whenever they so please. There must be reasonable grounds to believe that the rules are being broken, and if they were to conduct a search, they can find evidence of it.
Right, because everyone has privacy rights as set out by the charter.
You got it. Additionally, the judges of the SEC agree that the school authorities are in the best position to assess information about their school and the situations that are happening. So courts should recognize this special relationship.
Why is this preferred position necessary for school officials?
Again, school authorities are acting as agents of the state. Additionally, they hold special relationships with their students of the school that other people, like a police officer, for example, couldn't replicate.
Right.
Yeah.
Are there any other establishments the SCC has made as a result of this case?
We have a detailed number of specific situations in which there are reasonable grounds to conduct a search and seizure of a student, but overall the nature and credibility of the information received has to be assessed thoroughly by school authorities.
Right. That's all the questions I have for you. Thank you for joining me.
You're welcome.
Now, back to Shannon and Lewis.
Thank you, folks. There you have it. The SCC dismisses the appeal in the R versus MR case and establishes how search and seizure differs in an educational context compared to the general context.
Thank you for tuning in to our report.
Now, off to sports. Lewis?
The Toronto Raptors suck. Holy
All right. Thank you for watching our skit on the R versus MR case. To recap, the Supreme Court of Canada laid out 4 general principles about search and seizures in an educational context. Firstly, a warrant is not necessary in order to conduct a search of a student by a school authority. Second, the school authority must have reasonable grounds to believe that there has been a breach of school regulations and that a search would reveal evidence of that breach. Thirdly, courts should recognize that school authorities can best assess information relating to situations in their school, and they can determine if there are reasonable grounds that exist to conduct a search. And lastly, the following scenarios may constitute reasonable grounds for a search. Firstly, when information is received from one student considered to be credible, or secondly, when information is received from more than one student. Thirdly, from a teacher or principal's own observation, or if any combination of these pieces of information which the school authority considers to be credible. The compelling nature of the information and the credibility of these sources must be assessed by the school authority in the context of the circumstances existing at the particular school. So in closing of this section, these principles were laid out to establish that there is a difference between search and seizures in a general context versus an educational context. During this skit, we briefly touched on how educators are acting as agents of the state, and that affects the conditions surrounding search and seizure. So I'll now turn our presentation towards our salient points and the implications of search and seizure in an educational context. Firstly, due to the fiduciary role of educators and school administrators, they play a pivotal role in implementing search and seizure laws within schools. As such, they must work to maintain a safe learning environment, follow legal compliance, and ensure that students' rights are upheld. In other words, they must create a balance between crime control and protection of privacy rights. Overall, the main priorities of educators and school administrators is to protect students' rights and to maintain school safety by preventing dangerous or illegal activity on school grounds.
Privacy. In terms of the Charter, Section 8, Code of Professional Conduct, and the TQS, students have a reduced expectation of privacy in schools in relation to searches by administrators for the purpose of maintaining a safe school environment. Schools should dispel any notion of privacy by giving them a heads up on the students at the beginning of each school year that their lockers are school property and may be subject to search at any time given within reason. A reasonable reminder, schools have policies that allow for temporary confiscation. However, unless they have reasonable suspicion, they cannot search the device. That provides a great deal of assurance in safeguarding students' privacy barrier. Mainly, the big idea, or the TLDR that we're trying to come across, is that the court precedents confirm that students have reasonable expectations of privacy, and the school officials must work within legal frameworks to administer search and seizure. Now onto the Code of Professional Conduct. It primarily emphasizes following legal protocols that teachers must abide by those parameters set out by the law. The TQS mandates teachers to act with fairness, integrity, and legal awareness when handling discipline. Teachers must exercise reasonable suspicion rather than probable cause when considering a search. Teachers have the ultimate responsibility and duty to find the balance of care and authority in securing the safety for their students' environment. Ultimately, taking all of this into account, it informs how these factors play into search and seizure and teachers' role as agents of the state in the aspects of maintaining school safety.
So students have a right to be let alone, meaning that schools cannot randomly search them without a good reason. If a search is conducted without justification, then it is deemed an unreasonable search. In order to conduct a reasonable search, the Supreme Court of Canada requires school officials to have reasonable suspicion that the search will result in evidence of wrongdoing. This differs from probable cause, which typically involves some form of evidence of wrongdoing. In schools, the standard is lower, so reasonable suspicion means that the school has good reason to check, but they don't need absolute proof before searching. The Charter does not allow for unreasonable searches, even in schools. While school officials don't need a warrant to search a student, they must have reasonable suspicion to justify their actions. As mentioned previously, if the school decides to conduct a dragnet, this places all students under an unreasonable search, as the school cannot justify searching all students when only one is suspected of wrongdoing.
Previously, schools relied on ad hoc and informal procedures when investigating. However, now schools must adhere to special safeguards from the outset of any investigation of a young offender. Under the preamble of the YCJA, young people have a special guarantee of this evidentiary protection. Therefore, authorities must be particularly careful when dealing with young offenders. School officials may well be barred from pursuing a criminal prosecution in cases where informal searches or questioning procedures violated the protections afforded to young people and consequently result in the exclusion of evidence. So, with the YCJA and educators, it reinforces the protections of minors, including limitations on evidence obtained from unlawful searches. So ideally, police would handle questioning of students regarding potential criminal manners, and statements given by students, as mentioned previously, must be voluntary. So in section 146(2)(b), informing students of their rights, most children don't fully understand or appreciate their rights when received in a Miranda-type warning. So it's advisable for school boards to draft a plain language document to be used in schools for advising students of their rights. And students must also be informed that their statements will be used against them. School administration for initiating criminal proceedings against a student, again, informing students of the nature of their allegation, but also contacting a parent before an investigation takes place, as mentioned in section 146(2)(c), where teachers are advised not to let the students tell them things in confidence, thinking that their fiduciary relationship is extending to there, because these statements are admissible in court. So students have the right to counsel with an appropriate adult before making any statements to school authorities. So all in all, successfully balancing student rights with the responsibility of search and seizure requires ongoing education and policy adaptation. It is crucial to foster a safe and respectful educational environment by doing these few things: informing students of their right to counsel, displaying reasonableness of action in searching belongings and doing their best to not breach the charter, ensuring statements by students are made voluntarily, involving police when questioning about crimes, limiting the publishing of students charged or convicted, demonstrating reasonable suspicion rather than probable cause regarding the evidence, conducting searches under a reasonable and not excessively intrusive way, as well as not conducting strip searches as they are considered unconstitutional and conduct psychological harm on students. Thank you.